Welcome back to But Coffee First. In this episode today, we will discuss the Diddy and the Cassie lawsuit settlement. And we're going to shed some light on the factors that help contribute to its quick resolution. Before diving into the details, let's provide some background information first, okay? Recently, Sean Combs, also known as Diddy, was sued by Cassie, his former partner, for disclosed reasons we know about. While we won't delve into the specifics of the lawsuit, it is important to note that Cassie sought a specific amount for her pain and her suffering, and surprisingly, the lawsuit was settled within a remarkable short time frame, sparking curiosity and speculation. Coincidentally, this month, Diddy stepped down temporarily as chairman of Revolt TV, and he dissolved his partnership with a charter preparatory school that he had helped establish. This decision was influenced by 2 additional pending lawsuits against him. Now, it may have gone unnoticed by some of us, but these lawsuits target not only Diddy, but also his affiliate companies such as Bad Boy Entertainment, Bad Boy Records, Epic Records, Combs Enterprise LLC, and DOE Corps. So to better understand this swift settlement, it is crucial to examine the importance of commercial liability insurance and the directors and officers policy. Watch this video. I'm not a lawyer, but she is one.
It's fascinating to me. So that one was settled so quickly, I believe, because her attorneys were really brilliant. They didn't sue just Diddy. They sued his corporations.
They sure did.
And they sued his corporations and sued in her capacity as an employee. When you do that, it triggers commercial liability insurance.
Yeah.
And it triggers another policy called directors and officers. Okay, and we know he's a director of these companies as the CEO. So now you got 2 policies. What happens then is it takes away Puffy's ability to settle. It's not his choice no more.
So it's no longer personal accountability. It's his organization.
It's his organization. And it's no different than like if you hit somebody with your car. Mm-hmm. Let's say you have State Farm. Mm-hmm. State Farm gets to decide to settle, not you. You could say, I didn't run the stop sign. That's not true. They're lying. If State Farm says, we don't care, we did our investigation, we're settling. That's it. That's what happened here. So because they added those claims, the corporate insurance carrier got to say, read over it and say, oh, hell no, we giving her the money. Because if they don't, right? So also her lawyers, they get to write a letter. It's called a demand letter, and they get to say, we are demanding the limits of your insurance policy.
Oh, yeah,
that means
that'd have been crazy. Yeah.
And here's what's wild. If they read over it and they realize, based on these facts here, it would be reasonable to give that. If they don't give it to them, and let's say the policy is $30 million, but they go to trial and the jury gives her $250 million.
Correct.
They got to
pay $50. Yeah. And that discovery process and trial would have been
They got to
crazy.
pay the $250 million, and they got to pay the extra for all of his attorneys. If his attorneys alone cost $1 million, they got to pay that, even though it was only a $30 million policy. So basically, because of the facts and because it's now a corporate policy, Diddy don't have the right to settle anymore, and that's how it happened so fast.
Do you think that she got the full 30?
Oh, I know that she did.
You think it's full 30?
As an attorney, I believe so, because that's how it happens that fast, is because when you give them the policy cap, there's nothing to argue about anymore.
Wow.
Right?
No, you're right.
I didn't know it was that deep.
It is. That's the only time it goes that fast, is you take away what is there to argue about. And what's even crazier is the other reason because it went that fast, she didn't have to sign no confidentiality.
Agreed. And that's what's crazy to me. She could still write that book.
She gonna write that book.
This policy typically includes premises coverage. It's protecting the business from claims arising on its physical premises during regular business operations, right? And then there's claims made policies, which cover claims when they are made regardless of when the claim event occurred, while occurrencing policies also cover claims based on events that transpired during the policy's duration, even if the coverage has expired. For instance, a business may secure employment practice liability coverage to safeguard against claims related to wrongful termination, sexual harassment, and discrimination. Additionally, they may purchase insurance for like errors and omissions and like financial reporting, or coverage for damages resulting from directors and officers' actions, right? So these liability policies often cover legal representation on cost of settlement expenses, right? Insurers determine the cost of the commercial general liability insurance based on factors such as your business size, your operational risks, and your desired coverage, with prices ranging from $300 to $600 for $1 million of coverage. Unfortunately, the presence of commercial liability insurance triggered another policy, and that is known as the directors and the officers liability insurance. This coverage basically protects the individuals from personal losses that incurred due to lawsuits when serving as a director or officer of the business or the organization. D&O insurance resembles principles of corporate governance, corporate law, and fiduciary duty owed to the stakeholders, and particularly for publicly traded companies subject to robust federal regulations. Typically, the D&O insurance policy comprises of a Side A, a Side B, and a Side C coverage, okay? So Side A coverage protects the directors and officers when the company refuses or lacks the financial capacity to provide an indemnification with the individual officer's assets risks. Side B coverage applies when the company grants damages and they reimburse the legal costs, while the corporation's assets still face potential loss. Now, Side C, that's the big one, because this is called entity coverage, and it extends protection to the whole corporation entity itself with its assets at risk. Keep that in mind. Now, having familiarized ourselves with these policies, it becomes evident how they could impact Diddy's situation. Take a look at this second video, right? And why this lawyer is telling some interesting information.
I know that she did.
You think it's
As
full
an
30?
attorney, I believe so, because that's how it happens that fast, is because there's no, when you give them the policy cap, there's nothing to argue about anymore.
Wow.
Right?
Yeah, no, you're right.
I didn't know it was that deep.
It is. That's the only time it goes that fast, is you take away what is there to argue about. And what's even crazier is the other reason it went, because it went that fast, she didn't have to sign no confidentiality.
Agreed. And that's what's crazy to me. She could still write that book.
She gonna write that book.
Man.
And that's why he may have criminal something later. If the statute of limitation hasn't expired on that, I don't know. But in New York, if you settle in under 21 days, there cannot be no confidentiality agreement. And she also sued under California. California says if you're accusing them of something that could be a felony, which she is, then under no circumstances, 21 days or otherwise, you cannot have a non-disclosure, because the public should be warned and should be known, get the chance to know whatever it was he did to you.
Wow. So if we're hearing you, Diddy's public reputation is done.
It's done.
Yeah.
And if he wants to be able to leave anything to his children, he needs to walk away from all of these corporations.
Damn, he can no longer be the head of his corporations.
Well, remember, didn't I say directors and officers liability?
Yeah.
More than likely, what will happen is those insurance companies, they have the ability to say, we won't renew your policy if he continues to be a director or officer.
And you got to have
That's
that
why
insurance.
You
Vince
gotta have
McMahon stepped down, huh?
Yeah, that was the same reason.
Who?
A wrestler for WWE, the owner, CEO, he had to step down for a similar reason. And it was probably the same thing, didn't tie in that insurance.
Notably, Cassie did not sign a non-disclosure agreement. since under certain circumstances, such as ones that may involve a felony, New York law allows up to 21 days for disclosures to be signed, while California does not allow any time for that NDA to be signed. They want the people to know what you do. So in summary, the swift resolution of Diddy and Cassie's lawsuit can be attributed to the involvement of commercial liability insurance, as well as the directors and officers policy. These policies provide coverage for claims made against the businesses and their associated individuals, respectively. It's important to understand the significance of these policies, especially when dealing with insurance companies. As for Diddy, it remains to be seen what the future holds for him in these legal matters. In conclusion, it is essential to acknowledge the reality that individuals in the entertainment industry, and Cassie, undergoing these legal challenges like anyone else, their stories deserve to be heard. And transparency is crucial for a complete understanding of this situation. While we cannot pass judgment, we can hope for the best for Diddy and his family and everyone that's involved. Thank you for joining me on this new episode of But Coffee First. Make sure you guys stay updated for our new episode on YouTube on my channel at Coffee Brown ENT for your next episode. Don't forget to like, share, follow, and subscribe for your latest tea talk. Have a great day, guys.